Before the lunch break, we already started with the, let's say, novel idea of recording a podcast live during the IP Days with the Unified Patent Court. And as everyone know, European lawyers and patent attorneys talk about this for 10 years, but as we also all know, this has now been in effect for 2.5 years. And we wanted to take this opportunity today to share the experiences we gained with the cases that we have. So practical advice is really the key idea here. And so we have experts on our... Thank you. He's not part of our marketing, but thank you. Maybe should be. So we have not really a panel, but let's say presenters that all have handled cases at the UPC, not only one case, but multiple cases each, and with various different scenarios. Let's maybe start from the left to the right. It's Moritz Bloser, attorney at law with ample experience in patent litigation, more than 10 years, I believe. Plenty of SEP cases, and also has experience now with SEP cases at the UPC. With Andreas Kabisch, our head of the legal department at Meissner Bolte in Munich, and who's our, let's say, go-to or expert when it comes also to inspection proceedings, previously in national proceedings, in particular in Germany, of course, but now also at the UPC, and we're going to hear about this today. Jasper Verhan, patent attorney, but also UPC representatives with lots of litigation experience, and now also at the UPC, also inspection proceedings, but also isolated revocation actions, etc. Julian Würmser, also patent attorney, UPC representative. We worked together on SEP cases, and we gained some experiences in parallel EPO opposition and revocation actions at the UPC. Tilman Frank, we already seen him today, together with Jasper, of course, who's very prolific, who's very active, promoting UPC actions with Meissner Bolte, of course, and who was, I think, the first, maybe second, first isolated revocation action filing in Paris. So we also have some very good experiences there. And Niels Schuh, another attorney at law from our Düsseldorf office, but very closely collaborating with everyone in Munich as well, who has worked on several of these cases, also on the plaintiff side, defensive side. So we have basically the full spectrum of cases sitting in front of you. So we will start with some topics. We have, of course, ideas, but naturally, as before, we welcome any questions, in particular at the later stage, of course, that you may have, practical questions. Just as an introduction, I mentioned it yesterday, the last numbers we have are from end of June 2025. The UPC back then had 946 cases, so maybe we already cracked the 1,000 case mark, I'm not sure. And of all these cases filed, there were a total of 21 cases that also concerned requests for preservation of evidence or inspection proceedings. 3 of those should be filed by us. So let's start with the inspection proceedings at the UPC and your experiences there, and the differences in particular with respect to national inspection proceedings that we already know for a long time. Andreas.
Yeah, thank you. So maybe I will make a few preliminary remarks concerning inspection proceedings, because statistics say that you have not done any so far and have not participated in any. Like Florian said, only 21 have been filed and conducted yet, so a very, very small amount. What are inspection proceedings? Inspection proceedings are basically the German and the European answer to US-style discovery proceedings. So basically, what do you do if you don't have the necessary evidence that you need to file infringement proceedings? And in Germany and in Europe and in some other countries, you can do inspection proceedings, which means you go to the court, you explain to the court that there is a certain likelihood that someone is infringing your patent, and that you don't have the necessary evidence to prove this in an infringement proceeding, and you ask the court basically to help you obtain the necessary evidence so you can think about filing main proceedings with the evidence to succeed in these main proceedings. And what the court does is they look at your explanations. They look, is there a certain likelihood that someone is infringing your patent? And if the court finds that this is the case, they will grant you an order and allow you to go to a certain place to inspect products, obtain documents, or secure some evidence that you would need in main proceedings. For example, you have a method claim and you suspect a market participant that he is exercising the method claim with a specific machine that is only located on his premises, but you don't have the necessary evidence to prove this. So you can go to the court, file inspection proceedings, get access to the machine, and then have it reviewed if the method that you have protected is actually exercised there. And if this is the case, then if necessary, you can file main proceedings on the merits. So these are basically inspection proceedings in a nutshell. And even though they are not very popular on a common basis, with Meissner Bolte, we have done a lot of them because we basically specialized in them for our clients. And we have done over 50 national proceedings. But of course, the clients oftentimes come and say, can you also do these inspection proceedings in the Netherlands? Can you do them in Italy? Can you do them in France or in Romania? Because in the end, we would like to file the main proceedings in Germany. So we would also like to start the inspection proceedings with the German court. And until now, this was not possible. The inspection proceedings, the German inspection proceedings, were limited territory-wise to the territory of Germany. So we were never allowed to go outside of Germany to do inspections. But this is possible now with the UPC. And as Florian said, we already have done 3 proceedings, and these were not done in Germany. We did them in the Netherlands. So we now have the possibility for our clients to go somewhere to check if products are infringing their patents. And this opens, of course, a lot of possible strategies. We went to the Netherlands, of course, because it's a very popular country for imports. And you have the possibility to check goods as soon as they come into the country and are stored in a warehouse. So you can go there. You can take products from the warehouses. You can check delivery slips. You can get information where these products should be delivered to or are intended to be delivered to. So you not only get the products and information about the goods and if they are infringing the patent, you also get information about the scope of the potential infringement. You can see, are the goods intended only for one country? Are they intended for a multitude of countries? Where are they going? Where are they coming from? Who's the manufacturer? Who's the importer? So a lot of information that you can use then in potential main proceedings. Of course, in this case, also in front of the UPC. And important, only because you are inspecting in one country does not mean that you need to file the main proceedings in this country. You can basically then switch for the main proceedings to another country. So you can do the inspection in the Netherlands, but then the main proceedings in Germany. So these are strategies that you can deploy. If you are thinking about inspection proceedings and national versus UPC proceedings, there are some things you should consider. The requirements are in part very different. For example, in the UPC, you have an urgency requirement that you would not have with the most popular German courts. So that means if you have some indications that a market participant is infringing your patent, in the UPC, you should file the inspection proceedings without undue delay. Otherwise, you will not be able to meet the requirement of urgency. How long this is as a deadline is unclear. There is no settled case law yet. Again, there are only 21 cases in total so far. So if you can take 3 months before filing or 6 months before filing is unclear, but at least you should file as soon as possible once you have good indications about the possible infringement. This you don't have in Germany. Also different is...
No, I mean, probably also means that you need to include kind of like an explanation that you meet those urgency requirements and that kind of like bring some flexibility to the judges to say, well, in that case, maybe urgency is met, even though in another case with the same time frame, urgency may not be met.
Exactly. Yeah, that's a discussion that you can have with a court. Of course, if you have a very complex chemical patent, you will probably need more time to substantiate your suspicion that there might be an infringement than if it's a mechanical patent or something. So this is a discussion that you can have with the court. Also in regards to other requirements or benefits you have from the order. For example, if you go to Germany, you can do the inspection with a court bailiff and court-appointed expert, and also with the representative of the patent owner. So the patent owner can basically send a patent attorney and an attorney at law to attend the inspection and make sure that everything is in order and all of the evidence that you want to have is obtained. Whereas in the Netherlands, where we were now, the attorneys are usually not allowed to participate. So this will then be conducted by the court bailiff and the expert by themselves. The result is, of course, the same, hopefully, and certainly you will get the evidence that you need. Just the way you get there is slightly different in both cases.
Yeah, so I take that inspection proceedings are really a very strong tool that we have in our toolbox, a very efficient means, and it's very quick also to obtain such orders. What's the time frame from filing to obtaining such an order?
Yeah, in the Netherlands, we took around, one was 1 week and the other one was 3 weeks, but the court was very busy at that time. And the same you can also expect for Germany. The difference is the communication with the UPC court, at least with the local division in The Hague, was very pleasant. You can send basically emails to the judge, which would not be possible in Germany. So if you have questions or you need to have an update, then you simply can send emails, which is extremely comfortable.
Okay, so very quick, as we all kind of like expected from the UPC. Moritz, maybe we can talk about the duration of the proceedings, because that was one of the main selling points next to, of course, the territorial scope of the UPC, that we have very fast proceedings. What are your experiences with that?
Yeah, thank you. It's true. In the rules, it's mentioned that the goal is to conclude first instance infringement proceedings or proceedings in general within 12 months. In the beginning, they maybe to some point reached this goal. Then we had a middle part where it took quite longer, especially in Düsseldorf we've seen very long proceedings. We have one proceeding that started, I think, last year in July around, and it was written out. So the written part of the proceeding was finished already in February, March, and then it was scheduled for the oral hearing for December this year. So we are around 18 months, I think now it's even not next year. Now it's the new date, because this wasn't possible for all parties now in 2026. So we are way behind and more than 18 months. Also, we had 2 other proceedings in Düsseldorf, where also in one proceeding was also written out, and no oral hearing was scheduled at this point. And what I hear, same was here in Munich. They had also significant delays. For one reason, too, a lot of preliminary measures this were requested here in Munich, especially. Judge Siegand was very busy in this regard. And of course, these interim proceedings, they have priority in view of or compared to the main proceedings, which then also had the consequences that these normal proceedings on merits took longer, because they first needed to deal with all the interim measures. But now we have a second division, second chamber here in Munich. We have new judges in Düsseldorf, and now that they're all worked in and got some routine with the formalistic measures and so far, we are seeing that it's getting better. But I've also heard from colleagues from the industry that they're actually now going to Mannheim for some cases, because there's less backlog of proceedings, of cases, so they hope to be quite faster there. And Also here now in Munich, the 2 divisions, you don't have the guarantee anymore to come to Judge Sigan, which a lot of the patent holders was the main goal. And that's why also the big success of the Munich local division was maybe. And another aspect which comes into mind to this are the pending EPO opposition proceedings. So for one of the SCP cases we were dealing with, or still dealing with in the end, with Florian and Julian, for reasons we can't explain, the plaintiff lodged or filed the complaint 2 months prior to the end of the opposition proceedings. And with the UPC, it is still possible to have opposition proceedings and also parallel counterclaim for revocation. So you can do it in parallel. In Germany, for example, it's not possible. So if the opposition period is still ongoing, or if there are pending opposition proceedings, you cannot start separate nullity proceedings with the German Federal Patent Court. So we of course did both. We filed opposition and then requested accelerated proceedings, which is now possible if you have pending litigation. And to our surprise, the one case, actually the one we filed the opposition a month later, 6 weeks later, was then already scheduled for July this year. The other one is now scheduled for November this year. And then the court, actually after a request from the plaintiff, stayed the proceedings, both of them, even the one which was only scheduled for November. This was a little bit surprising for us because the initial case law in this regard more gave the impression that the court is not so inclined to stay proceedings due to at least first instance opposition proceedings. So there was the opinion that if the appeal decision is only 3-4 months away, then you have good chances that the court will stay the proceedings. But it isn't the discretion of the court. And in the first round, they gave the impression that they want to decide on their own and they don't care so much about opposition proceedings. But in our case, they stayed both proceedings. But this was probably also due to the fact that they had such a big backlog in Düsseldorf and were quite happy maybe to get 2 cases out of the way for a while.
I mean, just to put that into context, because you mentioned that Munich received 27% of all cases at the UPC, while Düsseldorf is 16%, Mannheim 10%. So those are the 3 most popular chambers. The Paris Central Division is because it's special dealing with the isolated revocation actions, as Tilman will explain, but they have 13%, but just that you understand, it's really the bulk of cases going to these 3 divisions, and so they have to, of course, adapt to this.
Maybe one quick side. So we hope it's get better now with the UPC, but interestingly to see is due to the lot of cases at the UPC, the German national courts are quite open for business, let's say. And if you really need to get something done very fast, the Munich district court is quite a rocket docket currently. We have a proceeding. We filed the complaint in beginning of November last year with service to Korea, and which actually failed the first time. So two times service to Korea, and we have the oral hearing now in 2 weeks. So after 11 months, oral hearing, national proceedings with service to Korea. So what
this is UPC panel.
But keep in mind, if you need something very fast, this can be an option.
Absolutely, I agree. Maybe moving.
Can I quickly butt in here? Just not that it comes back that the UPC is generally slow. So, I mean, what we saw in the past, it's an incredible achievement. So the system, of course, it started empty, but all the judges, they put everything together to manage their 12 months deadline in a completely new system with a halfway working electronic filing system. So I'm just saying, what they did is, from my perspective, an incredible achievement, and they are still really fast in average comparison. It's just what we note, and what Moritz kind of tried to elaborate a little bit. I mean, they're getting clogged up. The appeal, they try to kind of give them as an order, still try to kind of keep the fast pace going, but they're now, from our perspective, I think more it's fair to say they're trying to select a little bit and steer a little bit, and maybe have to acknowledge that they're not going to meet the 12 months every time. So in some scenarios, they might be slower.
Yeah. And keeping in mind that the UPC is dealing with infringement and validity at the same time, the German Federal Patent Court dependency of these cases in the first instance is more between 24 to 27 months still. So it's a huge improvement there. But maybe then coming to the isolated revocation action, how's the situation there? Do they meet the timelines? What's your experience?
They basically meet, yeah. I mean, the problem is sometimes the service of the claim, but this does not count actually. So as soon as it has been served, they meet their unofficial deadline of 12 months. In general, isolated revocation action, what is it? Is more or less self-explaining. It's a revocation action which is not dependent on any infringement proceedings, at least procedurally. In fact, they very often are dependent on any infringement proceedings. It has become very popular to raise an isolated revocation action when being attacked as a potential infringer. What many defendants are actually doing is that the defendants or the group of defendants files a counterclaim for revocation, and any affiliated sister company or so raises an isolated revocation action. This is several reasons and several advantages. One advantage is, of course, you have two shots. I mean, either, let's say, the infringement proceedings is dealt here in Munich. Either you convince the local division in Munich that the patent is not valid, or you convince the competition in Paris that the patent is not valid. The first reason. Second reason is a statistical one. At least it's worth considering it. The likelihood for revocation is higher at the central division compared with the local division. Difficult to say what the reason for this might be, but anyway, it is at least an argument, an indication that this could make sense, this double strategy. Last one is normally, not normally, you have to raise your revocation counter claim within a strict deadline of 3 months. You should not miss that. You should use this opportunity. However, very often it is the case that any further prior art is found then thereafter. Further prior art cannot be easily introduced into the UPC revocation, counter revocation proceedings. So in other words, very difficult to introduce it. Still, should you find it, very often it's, for example, prior use or something like that. This is a third reason for actually having or performing this twofold strategy, namely to have a new chance to get your newly found prior art admitted into the proceedings. So far to isolated revocation actions.
Okay. Yeah, so when we are talking about validity, I mean, Moritz already raised the issue that we can have, of course, we have the isolated revocation action at the central divisions, we have a counterclaim for revocation, and we have the EPO oppositions. And so as we hear now, we can have at least the EPO opposition and the counterclaim for revocation, or an isolated revocation action in parallel. And so, Julian, what are your experiences with regards to the differences between the EPO opposition proceedings and the revocation actions at the UPC? What does it mean for you as a practitioner preparing those cases?
Yeah, maybe quickly Moritz already kind of explained this. Traditionally, you would have this independent nullity action as a defense, as Tilman just explained it, or you would have this counterclaim for revocation. And funnily, it should normally not happen, because if you're kind of a smart patent owner, you normally would wait until your opposition period is over and then file your claim. But in reality, a lot of companies know that their claims, their patents, they are monitored, and they will run into opposition anyway. And so sometimes they're careless and they just file while they are still in the opposition proceedings. And in these types of situation, we were actually, like, for a long time, we were kind of struggling. What arguments do we bring where? What are the advantages and what are the disadvantages? So in the end, we ended up having a counterclaim for revocation within the proceedings, and we had our opposition. And what turned out quite nicely for us on the defendant side is that the EPO is the EPO, and the EPO is an incredible formalistic organization. They love added matter. Spent the longest time of my life explaining to the Americans what added matter is, and that kind of the skilled person is a no-brainer. And so we really, like, on these proceedings, we were able in our first opposition hearing to kind of talk 2 days long only about formal matters. I'm talking about added matter. We are talking then, when we have claim amendments, we are talking about clarity. We are talking about workability, and then we have a third ground that actually is not valid on the to come back to this comparison deal on the revocation action. You also have this bad Rule 80. I love it because at the very beginning of my career I ran into this one. It's basically when you amend your claims in the opposition proceedings, you're only allowed to amend things that directly address opposition causes that have been raised. So maybe, like, I mean, we Germans, we had this modernization of our writing system. So if you kind of start spelling the das instead of with the scharfe S, with a double S, that might cause issues. I hope not. But apart from that, there are a lot of situations where you're kind of tempted when you already file amended claims that you do, fix something somewhere else. And if you do this, you're going to run into big problems because, like, a whole set of claims just disappearing. So what we did in these proceedings, like, basically we chased the other guy from the left corner to the right corner, and we're really able to basically destroy the complete patent on formalistic reasons only. And from my perspective, I think there's a big, we already heard that each division does according to its national standard. And my expectation, and also what we've been seeing there, like with added matter, the Germans, like, whoa, our skilled person is pretty skilled. So you might not be very successful with added matter. And so definitely when you have these formalistic causes for revocation, it's really nice on the defendant side to have this strict procedure at the EPO. On the other side, with the real material reasons like novelty, inventiveness, and there was kind of a little bit of struggle from the left to the right. And from my perspective, for the longest times, it looked like there would be actually sort of different standards that would be applying, but maybe that's a good point to hand over to Tilman. Tilman is our harmonization fan, and maybe add on this a little bit on your side.
Oh, Jasper, yes, please.
Yeah, there's one aspect that one should also consider. We are all, as patent attorneys, used to opposition proceedings at the EPO taking 1 day, 2 days, 3 days. In the field of chemistry, 250 auxiliary requests are not a problem. That's quite common. And the UPC has made it very clear that they're not interested in listening to your patent attorney argumentations for longer than maybe 2 hours. You are limited in the number of auxiliary requests you can file as a patentee. The discussion on the patentability is short in our proceedings, so you should also consider this, that if you only attack the patent before the UPC, you really take away a lot of defensive headroom for the patentee, because at the EPO you can just keep filing requests and you will be heard in every single aspect, whereas I often have the feeling so far that sometimes the judges at the UPC are a little bit more slapdash when it comes to validity. And since you only have a limited number of fallback positions, you put a lot of pressure on the patentee to identify these fallback positions that are promising and still are infringed. So this is maybe the counter side to consider when thinking about filing an opposition at the EPO as well.
I mean, maybe just one aspect to add with regards to where should you file. Obviously, if you do the work and file your counterclaim for revocation, which you should, then filing the opposition, if you have the possibility, is not as expensive, and also there's less cost risk because there at the EPO we don't have an reimbursement of attorney costs for the other side, and so there's no real big cost risk involved in filing an opposition at the EPO. So it's always a benefit there. Coming basically out of these validity proceedings, you had to deal with that. There's the questions obviously that also then come. What is left with the patent once you have it when it comes to direct, indirect infringement? Niels, what are your experiences in this field?
Yeah, so of course, at the UPC, you deal not only with validity, but of course with infringement, which is the reason why you file an infringement action. And one aspect which we handled as a team was, of course, indirect infringement. And indirect infringement occurs when a device is delivered which is suitable for direct infringement. So if it's suitable to realize all features of a patent claim. This may be, for example, the case if a device can use a patent-protected method, or if the device is part of a patent-protected system. So what you keep in mind, for example, as an example is, for example, if a patent protects a printer with a printer cartridge, then delivering of the cartridge might be considered as indirect infringement. And what is required that the realization of all claims, so delivery and the use of the cartridge, then has to be realized in the patent-protected country. And of course, in national proceedings, formally this was the case when both happens in Germany. And here the UPC provides for greater protection of the patentee, where you can also assert cross-border situations. For example, where the delivery is coming from France and the product is being used in Germany. Under German national practice and also under French practice in this case, this could have not been asserted. But here, given the greater protection of the UPC, the options as a patentee are bigger. Of course, you should also keep this in mind as a potential defendant, that in some cases your FTO needs to be re-evaluated. But if you assert indirect infringement, what is also a legal topic that you have to keep in mind is exhaustion of rights. And if you put a product on the market as a patentee, then your rights are exhausted. We heard about in the last IP days quite a lot about this. This principle of exhaustion is in every European country given, and it's also stipulated in Article 29 UPCA. So what we're seeing in the first decisions of so the question is, if just a part of his patent-protected system is being delivered, can you still assert the claims? And in its first decision of the UPC adopted a very German approach and saying if the spare part which is being delivered has a certain technical effect, then you still can assert your rights. So your rights aren't exhausted, which leads also to a very patentee-friendly system at the UPC, where you can, in particular, also the spare parts where you might have a special business focus on it, be better look for better protection of the spare parts.
Yeah, so that's a very and sometimes a bit overlooked topic, even though, as Niels mentioned initially, one of the big pros of this bigger territory that we now cover, that we have all the deliveries from the various countries, where maybe now we can use the indirect infringement, or even it's now a direct infringement, which it was not before.